Okay. All right. It's now yet 2 o'clock.
Let's say it's 2 o'clock. I think we can start.
Okay. A very good afternoon, everyone. A very good afternoon. And let me welcome each and everyone to day one, the very first day of the 5-day training, employment law training put together by the MBA Institutes of Continuing Legal Education. The session starts today and continues tomorrow. For today, we're privileged to have with us the Honorable Justice I.G. Iwineka and my Lord of the National Industrial Court, Lagos Division, will be taking us on a very focal point when it relates to the National Industrial Courts. adjudication of employment law disputes in the court. As we all know, the industrial court, the subject matter jurisdiction of the industrial court is fairly settled or narrowed to matters relating to employment law, labor, and industrial dispute. But again, just as is the case with courts of limited jurisdiction, the amplitude or the extent of the jurisdiction of the court in itself continues to be a matter of engagement, or if I could say, to a large extent, disputation, judging by the diverse interpretations coming from the court on when a matter would be said to have elements of what will make it not an employment law matter that can be resolved or looked at the industrial court. And this has left it almost in a state of flux that it's almost difficult to ascertain with exactitude whether a factual dispute that seems fairly settled to be employment law related is one or will be one that the court would be able or we feel able and competent to exercise jurisdiction on. So we thought that to have a conversation around employment law, it is important to start with a discussion, a conversation around the jurisdiction of the court that I've said, or that we all know, is donated with subject matter jurisdiction or limited jurisdiction. Again, I welcome each and every one, but more importantly, permit me to welcome my Lord, the Honorable Justice B.B. Kanye, PhD, OFR, the President of the National Industrial Court, who, just like my Lord, Honorable Justice G. Winneker, they are both on vacation, and we thank them specially for taking time, even when they should be resting, to oblige us to have this conversation around the court or the jurisdiction of the court. We, on behalf of the ICLE, of the NBA and the NBA, we thank my Lord especially, and indeed every other judge of the industrial court present at this session. So that said, I would now want to invite my Lord, the Honorable Justice B.B. Kanye, to have preliminary remarks on the subject matter of interrogation today, which I said is jurisdiction of the court. My Lord, Justice Kanye, you're most welcome, sir.
Thank you. It's morning here. So
I yield the floor to my Lord.
Can I say good morning? I know back home it's afternoon.
Yes.
Can you hear me? Can you hear me? Can you hear me?
Oh, my Lord, hi. I think we cannot hear. My Lord would have to unmute.
I can hear, my Lord.
Can you hear me?
I can hear you, my Lord.
Okay,
Yes.
sorry, I'm trying to connect.
My Lord, we still cannot hear, my Lord.
I'm trying to connect.
You.
Hello?
Hello, my Lord.
My Lord is still muted.
My Lord, we can hear you.
It's not muted. I can hear him.
Ms. Lared and Folabi is like,
my Lord, apologies.
Me.
My Lord, apologies. I can hear my Lord. It's not
okay,
muted.
Okay.
Yes, I can hear my Lord. Yes, sir. I think it's from my hand. A very good afternoon.
I have to use the phone. My computer is saying the Zoom I have is outdated. I need to update it. And it's taking a while.
Oh, thank you so much, my Lord.
So I have to use the phone.
Thank you so much, my Lord.
I need to congratulate you first. I think this has been done under the auspices of the MBA Continuing Legal Education Institute.
Yes, my Lord. Yes, my Lord.
So I must congratulate you for the keen interest you've taken in matters of labor law, particularly.
Thank you so much, my Lord.
Just one or two few remarks. not necessarily a lecture as such, knowing that my brother Justice Nweneka will be talking more detailedly about the issues. I just want to stress one or two things.
Yes.
So far, since the third alteration,
Yes, madam.
it came into being in 2011.
Thank you, sir.
4th of March to be very specific, which means we've spent over 10 years trying to work it out, trying to understand the scope of it and the ambit, how far we can go. One or two things have actually been revealed over time. We still are yet to determine the scope, the ambit of the jurisdiction of the NIC in virtue of the third alteration. I did a matter some few weeks ago. In fact, I think I delivered the judgment on 26th of July, where a very young lawyer was the one who drew my attention to the fact that, firstly, Section 254C1 uses the word labor separately from employment. That if the two words meant the same, the choice of one should have covered the other. And in any event, that those words are prefixed by the word any. And if you look at the dictionary definition of any, it suggests a range of class of items that is almost like inexhaustible. So when you say you have jurisdiction over any labor, and you want to give the individual dictionary meanings of any first, then labor. Of course, by the time you add employment and so on, you discover that the jurisdiction is wide, very wide indeed. In fact, I did a mental calculation the other day in section 2546, the word any or anything. That is, if you take the word any in its individual sense or in conjunction with thing, anything, it's being used about 42 times in section 254C, generally in the Constitution. So when you use the word any to describe the jurisdiction of the NIC in relation to industrial relations, in other words, any employment, any labor, any industrial relations, any trade union, there is something that is very specific, and that is that the drafters of the third alteration didn't want to leave anything in doubt. That's the first point I want to stress. The second point I want to stress is that the jurisdiction of the court itself, like I said, is pretty wide. If the drafters wanted the status quo to remain, there would have been no need for third alteration. I think it's a simple thing in drafting. We are all taught in law school that the legislature often makes legislation to solve a problem.
Yes.
Because if there is no problem to solve, there will be no point making the law in the first instance. So we always approach the third alteration as if the status quo is what is still in place. And I don't think that's the right mindset to approach the third alteration. If the drafters of the third alteration wanted the old common law labor law to remain, if they wanted the status quo to remain, if they wanted you can hire and fire at will, with reason or without reason, you won't be making provisions as to jurisdiction in relation to unfair labor practices. You won't be making a provision in relation to labor law as to mandating National Industrial Court to apply international best practices and so on. So I want to believe that the drafters never wanted the status to continue. So this is the mindset we need to carry into the interpretation. We are told that when it comes to jurisdiction of a court can espouse on its jurisdiction, but it cannot expand it. So when you are espousing words like any labor, how can you be restrictive? And then more so, when you look at the opening words of section 254C1, notwithstanding sections 251, 257, 271 or 2, and anything contained in this constitution, and anything contained in it tells you that everything about the constitution itself, when it comes to what section 254C1 says, has to take a secondary role. If we continue with the mindset that the old order remains, then we are not giving the third alteration the deserving interpretation it requires. And I see some of these things going, even some of the Court of Appeal decisions I have read. You find that the same mindset about the old order remaining still there. And that's why you are going to find, even when the context does not suggest it, you're going to find cases in the Court of Appeal which say, for instance, I know of a particular case, I can't remember the name, where in very specific terms, the Special Court of Appeal, an issue of vicarious liability, Court of Appeal said the jurisdiction of the NIC under section 2541 cannot stand if there is no employment relationship. Now, how can you interpret section 254C1 in the context that all the items there apply only when there is an employment relationship? I always like to ask the simple example. If you know anything about strikes, we have what we call primary strikes, we have what we call secondary strikes. Secondary strikes or sympathetic strikes are where, let's assume, ASU is on strike and JUSUN decides to go on strike in solidarity with ASU. Of course, when JUSUN goes on secondary strike or sympathy strike in respect of matters relating to ASU, members of JUSUN are never in an employment relationship with the universities where ASU is primarily the workforce. Are you saying that NIC cannot entertain a jurisdiction over that secondary strike simply because there is no employment relationship between JUSUN members and the universities? So these are some of the misplaced interpretation and mindset that we carry into the third alteration, which I am urging we must look at differently. I made the point that I did a judgment on 26 July on the issue of interpretation of any labor. The outcome of which was a simple question. Does NIC have jurisdiction over contracts of service as distinct from contracts for service? Now, my attention was drawn that I should take these words more closely, look at them more closely. I acknowledge before then, even at the NIC, and there's a Court of Appeal decision where it was very specific that NIC does not have service. In other words, where independent contractors are involved, NIC does not have jurisdiction. We have held such, I have personally upheld it. But when my attention was drawn that I should take a closer look, I had to go back and take a closer look. I came across, of course, decisions like Shino Securities versus Afro Park, a Supreme Court decision given as far back as 2008, where the Supreme Court was ready to hold, in fact, not ready, held that the supply, a contract for supply of security guards by one company to another company is a contract of service. That's the Supreme Court decision, which was not factored in by the Court of Appeal decision that said NIC does not have jurisdiction over contracts for service. Now, we are all accustomed to understanding employment relationship from a binary perspective between two people, an employer and an employee. And the employee is very often, in our mindset, a person, an individual. But here is the Supreme Court saying a contract between one company and another company for the supply of security service guards is a contract of service. Is that not telling us something? Is that not telling us that, yes, in any event, when you look at the literature in ILO, ILO is very specific that, look, when you come to determining employment relationship, forget what the parties call it. Using what they call the principle of primacy of fact. It says, lift the veil and look at it more closely. If the relationship suggests an employment relationship, hold it. And that's why ILO, for instance, calls triangular relationships as disguised employment relationships. Because today, given the new forms of work and the tussle between flexibility, which is what employers want, and security in the workplace, which is what workers want, employers are daily evolving new forms of work. And very often, they evolve these new forms of work in manners that suggest that what you have as a relationship is not an employment relationship, but one involving an independent contractor. And why are they doing so? Because employment protection law, employment protection benefits don't, in quotes, apply to independent contractors. It only applies to employees. If you go to England and you read the Uber case, which went up to the UK Supreme Court, for instance, you're going to find very specifically the UK Supreme Court holding that Uber drivers are not independent contractors, that they are workers. And why did they do so? They said the level of control over them is suggestive of an employment relationship. These are jurisdictions that are ready to lift the veil and look more closely at the relationship. This is what we call for in Nigeria. This is what we call on lawyers to do. I told colleagues and I told friends, I said, when ILO lays down standards in the world of work, they don't make the distinction between contracts of service and contract for service. They simply lay down standards for the world of work. So why can't we be that broad-minded? In any event, let's be realistic with ourselves. NIC is the only court that can apply international best standards. And international best standards can go for or against. In fact, only recently, a 2023 decision, Justice Ogu Miju, in a concurring judgment, in respect of a cause of matter that arose in 1995, long before the third alteration came about, advised employers in a redundancy matter to have regard to international best practices. And why was my Lord saying so? Section 20 of the Labor Act does not lay down the parameters for redundancy. And if it does not lay down the parameters for redundancy, it means we must look elsewhere for the parameters. And luckily, you have a court that says apply international best standards. Only the NIC has that constitutional mandate, not any other court. If you go to a high court and you are applying international standards, you are going to face a brick wall. But if you come to NIC, you are going to have it easier because there is already constitutional mandate to apply. So even the application of international best practices is not something that you say is advantageous only to an employee. Even the employers can take benefit of it. Because within organizations, I understand organizations evolve and develop their own culture. And when they develop their own culture, if you can show it that, look, an employee came into a system and met this culture, agreed to it, subject, of course, to the rules of proof, because I think the evidence act talks about corroboration when you deal with conventions and usage. It's in this light I'm calling that the general discussion for the next 5 days. I understand my brother Justice Nweneka will be talking something about loans, mortgages, and so on. This is the sense in which I urge that we look at some of these things. I know of 1 or 2 decisions that have, for instance, held that once a loan is given in the workplace, it's a banker customer, particularly when you're dealing with banks. And I ask a simple question. When the conditions of service make provision for loans, what we call staff loans, and then lays down the conditions upon which the loan is to be given, the conditions upon which the loan can be recalled, the percentage, very often not commercial rate, how can you say it's a banker customer issue simply because it is a bank? I work in a court. If government tomorrow wakes up and says we are going to give car loans to workers and the parameters are set down, what has banker-customer relationship got to do with that? I've always asked a simple question. When faced with a borderline case, ask yourself a simple question. Which law will I use to resolve this problem? If it is employment law, then NIC has jurisdiction. If it is some other law, then NIC may not. And that is why, for instance, up till now, NIC does not take issues of employment tax, because the law to resolve those issues are laws in taxation, not in employment law. You have a system and organization where the conditions of service make provision either for staff loan or make provision for staff houses, and the parameters are set down in the conditions of service. How can you resolve such a problem using banking law or landlord-tenant law and things like that? These are some of the things I'm urging you are going to take more time to look into. I'm sure various perspectives are going to come. The engagement must continue. So like I started, I must congratulate you. I must also note that of recent, even the employer group, in fact, on 2 or 3 occasions, NECA, that's the Nigerian Employers Consultative Association, have invited me to talk to them on issues like this. I have always said that lawyers need to begin to go back to school to learn the issues of the third alteration. What you are doing is in good light. I'm expecting that the other stakeholders, which are the workers, because I've discovered there's a good deal of misunderstanding of what the NIC does, even by the workers, that everybody assumes the court is their own. I discovered that there's a good deal of misunderstanding even on their own part. I am hoping that they too will begin to run programs like this so that they can begin to understand the nitty-gritty of what the NIC stands for, what the toll alteration is all about. I can tell you the fine thing in the toll alteration are many. Only programs like this can bring them out. And I hope that you will not relent, and this will not be an only event. It's something that should be continuous. Thank you.
My Lord, I must say that on behalf of the ICLE, we thank my Lord greatly. That's on the first part. I must also be quick to point out that it is always refreshing to listen to my Lord's incisive thoughts on these matters. And a lot has been said on the subject matter that we're looking at. Interestingly, we're looking at a subject matter jurisdiction that the Constitution has conferred on the courts. And indeed, it is worrisome that there is a growing body of case law now dealing with jurisdiction of the industrial court, which I pointed out in some paper some time ago, that if care is not taken, the court might also fall into the same peril that the Federal High Court fell into. And what exact? The Federal High Court came in 1973 as a specialist court, enumerated subject matter jurisdiction. And as at 10 years ago, when I did the research on the number of decisions emanating from the Federal High Court as a court of first instance, going through the Court of Appeal up to the Supreme Court, I found out that 70% of those cases were cases dealing with jurisdiction. I mean, what is the jurisdiction of the Federal High Court in relation to banker customer? What is the jurisdiction of the Federal High Court in relation to maritime, or what appears to be maritime, but it's not maritime, should go to State High Court. And increasingly, as of today, what you find out is that not many subject matter, substantive decisions of the Supreme Court on those enumerated subject matter jurisdictional limits of the Federal High Court are available, because 90% of the time, what happens is the jurisdiction. Once the matter is filed, a preliminary objection is raised almost immediately that the court doesn't have jurisdiction. It is gradually beginning with the industrial court. And just like my Lord said, it is engagement like this, sessions like this, that we actually get to interrogate and perhaps get to look at it a little bit closer, whether it is worth many of the objections being raised, and for which the Court of Appeal, as at present, would appear to be even in a state of flux as to the decisions coming from the court on matters that, on the one hand, the intermediate appellate courts would agree the industrial court had jurisdiction, and the other, in the same breath, in the related factual dispute, the court takes a view that, no, it's not a matter that should go to the industrial court. It should be for the court of unlimited jurisdiction. And one important thing which my Lord has pointed out is the need to approach it with a broad mind. I mean, it is that broad-mindedness that I must salute and commend my Lord for even pointing out that the word any occurred 42 times in section 254. Any. So that in itself will readily suggest or is indicative of the broad-mindedness of the legislature as to what is the dispute that can go to the industrial court. But I'm sure that my Lord, Honorable Justice Iwineka, is ready to deal with this, the jurisdiction of the industrial court, as it relates to, which again is a growing body of case law that appears to be in a state of flux. And when the industrial court will be said to have jurisdiction on staff loans, mortgages, and other employment-related arrangements, and when the industrial court would be said that no, the court does not have jurisdiction on it, it should go to a court of unlimited jurisdiction. That said, I think the stage is clearly set to invite my Lord Honorable Justice G. Wineka. The representation precedes itself, so I would not as much as waste time to go through reeling out my Lord Lofty CV. I think my Lord can now say now. Thank you so much, my Lord. Yeah.
Thank you.
Yes, my Lord.
Good afternoon, my Lord. Good afternoon, distinguished panelists. Good to see my Lord again.
Thank you.
Good afternoon, distinguished panelists, and good afternoon, participants. It is indeed an honor to be invited by the MBA Institute of Continuing Legal Education to anchor the proceedings today dealing with the jurisdiction of the National Industrial Court of Nigeria as it relates to loans, mortgages, and employment-related arrangements. I must say that the views expressed here are not the views of the National Industrial Court. They are my personal opinion, and they are intended for discussion and enlightenment purposes. So please do not come to our court to say that this is what I said, and so we must rule in a particular way. Jurisdiction is pivotal to any adjudication, and that is why it is often regarded as the life wire to any adjudication. And it is clear that no amount of logic can confer jurisdiction in a court where it does not have. And if a court lacks jurisdiction in respect of the matter before it, whatever it does, it's a nullity. And there are so many authorities in that regard. And jurisdiction is the power of the court to decide on the matter before it. It is the limits imposed on the powers of a validly constituted court to determine matters presented to it by reference to the persons, the subject matter, and the relief sought. I must point out that there are three key issues here. One is with reference to the subject matter. The second is with respect to the persons, and then the relief sought. These three factors are exclusive.
Here for the five. L22. L22. Yes. That's back. Yes. Goodness.
And the lack of one will affect the jurisdiction of the court to handle the case. So the mere presence of one does not exclude the insistence on the presence of the others. This is what the Supreme Court has said in Angadi and PDP. And the jurisdiction of the court is often confused with the competence of the court. They are not the same. While jurisdiction is conferred by the Constitution or Statute, the court is competent when it is properly constituted with respect to the number and qualification of members. The subject matter is within its jurisdiction, and there is nothing that prevents the court from exercising its jurisdiction, and it is initiated by due process of law upon fulfillment on the conditions precedent to the exercise of its jurisdiction. This is what was set out in Madukolu and in Kendile. But a court must have both jurisdiction and competence to be properly seized of a matter. Perhaps I should mention here that when we talk of the jurisdiction of the court, there is substantive jurisdiction and there is procedural jurisdiction. The substantive jurisdiction basically relates to the jurisdiction as conferred by the statute or the Constitution, while the procedural has to do with things that must be put in place for the court to exercise its substantive jurisdiction. Also, the next point I need to make is that while parties cannot by consent confer jurisdiction on the court where it does not have one, procedural jurisdiction can be waived or corrected. And I've cited an example such as issuing a pre-action notice, filing and service of processes. Those are procedural issues that the court can of its own or on application by the party have the error or irregularity cured. That takes me to the jurisdiction of the National Industrial Court. The jurisdiction of the National Industrial Court has been a subject of intense debate that the President has highlighted in his introductory remarks, and also of judicial interpretation. Our focus today is the jurisdiction with respect to employment-related laws. Unquestionably, the jurisdiction of the National Industrial Court is both statutory and constitutional. So much has been written that I need not bore you with the history of the National Industrial Court. Suffice to say at this point that the jurisdiction of the court is donated by Section 7.1 of the National Industrial Court Act 2006 and Section 254C of the 1999 Constitution as amended. I have set out the provisions of Section 7, subsection 1 of the National Industrial Court Act. And there's Section 254C, which the President has equally highlighted. And one thing that we see, from the Constitution. What is clear, the words relating to, incidental thereto, mean likely the same thing, and indicate that the causes or matters must be linked with labor, employment, trade unions, etc. We see from the Court of Appeal interpretation of the jurisdiction of the court that there are often confusion as to the real extent of the meaning of the words relating to, incidental thereto, or connected therewith. The first case of Salami and National Judicial Council, while the court acknowledged the exclusive jurisdiction of the court in matters relating to or connected with labor, trade disputes, and industrial relations, added the phrase, other ancillary matters. I've had to read the provisions of section 254C several times to see if the word appears or in any of the provisions. There's no word ancillary used in setting out the jurisdiction of the National Industrial Court. And you'll agree that the word ancillary means completely different thing from relating to, connected with, or incidental thereto. While those words mean the same thing and mean that it must be linked, ancillary means dependent on. So the subject matter does not have to depend on, but must be connected or linked to labor or employment. So these are some of the confusion with the interpretation of the jurisdiction of the National Industrial Court. Then the court went ahead in the case of Kano State Government and Mohammed, Justice Abiru JCA. He explained that the relating to, that the consensus is that this gives industrial court exclusive jurisdiction over all matters relating to or incidental to employment relationship. Again, this gives a narrow interpretation of the jurisdiction of the court, because the court also has jurisdiction over matters involving child labor, child rights, and trafficking in human persons. But the Court of Appeal in Wabo and NIA, I think, gave the best definition or explanation of the jurisdiction of the court. There the court said that the words should be read as being inclusive and not exclusive. What that means in the words of the president is that when we look at the words any, it should be words that include and not exclude things relating to the core subject area of the court. And I think the Mwabo and NIA remains the best explanation of the jurisdiction of the National Industrial Court. In the Higeba, a Medical and Health Workers Union of Nigeria, and Dr. Alfred Higeba, the Court of Appeal again said it is now a settled principle of interpretation of statutes that the lawmaker does not use words in vain. He says the argument is that the words connected with, related to, pertaining to, arising from, incidental thereto, connected therewith, used by the lawmaker to reiterate the wide jurisdiction of the National Industrial Court over all employment and labor dispute, regardless of the nature of the claim and of the parties to the suit. This definitely gives the court the latitude in expounding its jurisdiction without necessarily expanding the same. However, the Court of Appeal in Ekoba and Efiokosu held that the court is a court limited by the matters closely related to labor and employment. Again, that is an error. And then added the phrase, a claim cannot be considered as ancillary to the main claim, which is completely removed from the subject matter of the main claim. Again, the word ancillary appears, and the jurisdiction of the court is not defined by the word ancillary, but relating to, or connected with, or incidental to. So there must be a connection, not dependent on that. In Central Bank of Nigeria and Gabriel Odo, the Court of Appeal again said the court is a strictly labor and employment-related court. What appears from the above decisions is that while the Court of Appeal seems to acknowledge that the repeated use of the words connected with, relating to, pertaining to, arising from, incidental thereto, or connected therewith in section 254C of the 1999 Constitution as amended, indicates that the court has exclusive jurisdiction over issues arising from employment and labor. It appears to circumscribe the court's jurisdiction in its various decisions, especially in cases involving employee-related loans. And this will engage our attention shortly. I've asked the question, what is an employee loan or mortgage? In practice, it is not unusual for employers to provide financial accommodation to meet various employee needs. The accommodation ranges from salary advances, asset acquisition loans, share purchase loans, and housing loans. There are also facilities like examination loan and home improvement loans. Repayment is usually tied to the salaries of staff and monthly deductions are made. A majority of these facilities are not collateralized. Where the facility involves housing loan, the employee is often required to deposit the title documents and execute a mortgage agreement or deed of legal mortgage, in addition to the monthly deductions from his salaries. Well, while the employment relationship subsists, there's usually no problem. But problems emerge upon cessation of employment relationship. And after the Third Arbitration Act, the National Industrial Court has been faced with the need to interpret, to deal with these cases or with claims on recovery of employment-related loans. The attitude of the court in each case depends on the facts and circumstances of the case. The often cited case is Zenith Bank PLC and Odige. This is a case that was terminated at the preliminary stage, where the court held that it does not have jurisdiction over mortgage and personal loans. We shall come back to this in the course of the discussions. And the facts of the case are simple. The employee who was a senior staff resigned his employment and went to the High Court of Lagos State, secured judgment. The bank came to National Industrial Court to enforce the mortgage agreement. The court declined jurisdiction and struck out the suit. The court held, and it is important that I read what the court said. So they look at the statement of facts, reveals that the averments are not related to or connected with any dispute arising from payment or non-payment of pension, gratuity, allowances, benefits, and other entitlements or employment. The averments are with respect to the loans the defendant was given while in employment and his alleged indebtedness. Well, but in Vivian, Folayemi Asena, First Bank of Nigeria, a decision that was delivered by the president of the court assumed jurisdiction over mortgage loans and upheld part of the counterclaim. In Keystone Bank, and Nonso Odibo, a case that I also handled. The judgment was delivered on 12th October 2020. Relying on the ruling of the president in a sister case, I assumed jurisdiction on the recovery claim and entered judgment on the facts in favor of the bank. The defendant appealed this decision and succeeded. The citation of the Court of Appeal is given, and the judgment was delivered December last year. And because of the reasoning of the Court of Appeal, I seek your indulgence to read some of the statements by the learned justice of the Court of Appeal, because it will form the bedrock of our discussions today. The facts simply are, the defendant was an employee of Bank PHB, Platinum Habib Bank. He resigned in 2010, but at the time he resigned, the bank did not ask him to pay back the loan he took. Bank PHB was taken over by Keystone Bank in August 2011. On 2nd October 2013, the bank made a demand on him to pay the loans. He ignored the letter. The bank solicitor wrote, he ignored the letter. The bank came to court. And after full hearing, judgment was entered in favor of the bank. He went to appeal on one issue essentially, and that was that the court lacked jurisdiction to entertain a claim on personal loans. Justice Otisi, who delivered the leading judgment, had this to say. She said the court found that the loans were not staff loans, or loans advanced to him in his capacity as a customer of the bank. The court said, a close scrutiny of Exhibit 1, which is the letter of employment, does not reveal that one of the terms of the employment was that he must open and operate an account, or that a staff loan or a staff account with Bank PHB. None of the terms of the contract of employment indicates that he's entitled to receive a loan from the bank, his capacity as a staff of the bank. That was one of the bases of the court holding that it was not a staff loan. Then the court went ahead and also found that the respondent, which is the bank, did not adduce evidence to prove that the facility was a staff loan. In our words, say a loan facility has not been shown to have been tied to the employment terms of the employee. A loan facility has not been shown to be tied to the employment, contract of employment. Must remain distinct and separate from the contract with the lender banker. And then further, the loan was advanced to the appellant as staff loan and thereby incidental to his employment by Bank PHB. So the court gave the reason that for the court to have jurisdiction, there must be evidence that it was a staff loan, thus drawing a demarcation between mortgage loans, personal loans, and staff loans. Earlier in registered trustees of Self-Reliance Economic Advancement Program and SEDEAT, OIJC had noted, say, I am of the humble or firm view that staff loan granted to the cross appellant has nothing to do with the appellant's contract of employment. The loan contract, which is personal, has nothing to do with our employment, except that the agreed 55,000 naira deduction was to be deducted from our salary on monthly basis. So here again, the court not only did not make a distinction between staff loan and personal loan, the court said there was no relationship whatsoever between the facility granted to the employee and her contract of employment. Relying on these cases, in Royal Exchange PLC and Osisioma, I declined jurisdiction and struck out the claim. I said this, Relief 360 a declaration that as of 30th November 2018, the defendant was indebted to the second claimant to the tune of 3,429,778 naira under the loan facility availed to the defendant by the second claimant by virtue of his employment with the first claimant. So in this case, there was an indirect facility granted by a subsidiary of the first claimant. The first observation is that the letter is addressed to the defendant in his personal capacity. Paragraph 1 reads, we refer to application dated, I'm sorry, I read what I said in the last judgment. We refer to application dated 10th August 2016, requesting for a review of some of the conditions in the offer letter, and I'm pleased to inform you that management please, I'm very sorry, I'm unable to. Management has approved the review of the letter under the following terms and conditions. One thing I observed is that the terms and conditions are similar to the terms and conditions of personal loans. The condition precedent to draw down, including receipt of upfront fees, receipt of title documents on the property, and receipt of the loan agreement and indemnity agreement form. So this clearly took it away from the usual staff loan to more of a commercial loan. As a result, the court declined jurisdiction. Now, what is I also said that, therefore, I held that the court transaction is not incidental to the defendant's employment. What is more, from the evidence before me, there is no employment relationship between the claimant, between the second claimant and the defendant. So this case was decided on its peculiar facts. Arising from this, sorry, missed it. I'm very sorry. Missed it. So summary of the key points from the decisions. Undoubtedly, it is the subject matter that determines whether or not the National Industrial Court will assume jurisdiction in any given case. And in determining jurisdiction, it is the claim endorsed on the originating process that will be considered. What emerges from the decisions that we have highlighted above is that one, whether the National Industrial Court will assume jurisdiction on employment-related loans will depend on the facts and evidence before the court. Like the President said in his opening remarks, the primacy of facts is critical to the success of a claim relating to employment loans in the National Industrial Court. If the facts show that a facility was a staff loan, the NIC will assume jurisdiction. And I need to delete the fact that it is a personal loan for this purpose based on interpretation of section 254C, subsection 1, paragraph A. It is immaterial at this point whether it is a mortgage, whether it is a personal loan, and whether it is a strictly staff loan. What is material is that the documents, the employment documents, that takes me to the second point. The loans must be made an integral part of the contract of employment. That is to say, the letter of employment, the employee handbook, and all the processes written to the grant of the facility must integrate, must make it conditional upon the employment and remaining in employment. What I've tried to say is that it should be a term of the contract of employment that the employee maintains an account with the employer where the employer is a financial institution. This was what happened in the case of Odibo and Keystone Bank Limited. The Court of Appeal was of the view that the opening of the account was not a condition of the term of employment. Consequently, the court held that it was not a staff loan. Going forward, it's important that the contract of employment makes it a condition that employees for banks and financial institutions will open accounts with their employers as a condition of the employment. In addition, the letter of employment, the conditions of service must create a platform for the employee to access the loans. Some of the banks already have this, and some other companies also provide employee loans. But there has to be a link between the letter of employment and these employee handbooks to confer jurisdiction on the court. Much more importantly, the pleading and evidence must be detailed enough and supported by documentary evidence. Nothing should be left to chance. On the basis of the decision of the Court of Appeal in Odibo and Keystone Bank, the court did not rule of the possibility that the National Industrial Court still has jurisdiction over employee-related facilities. However, the court insists that there must be a connection between the conditions of employment and the facility. Where such connection does not exist, the National Industrial Court will not have jurisdiction. In conclusion, it is beyond dispute that the National Industrial Court had jurisdiction over employment-related facilities insofar as they are related to the contract of employment. This is so even when the employee is compelled to resign from his employment. Each case will be determined on the basis of its facts and merit. Thank you for your attention.
My Lord, Honorable Justice Wenega, we thank you for that well-researched and well-delivered paper. Thank you again and again. I'll now go on to, without much ado, I'll go on to the question and answer session. Apologies, I forgot to mention this when we started, but if you still have questions, kindly leave your questions, comments, observations in the chat box, and we'll pick it from there. In the meantime, I would go through some of the questions. It's interesting. When my Lord spoke, quite a number of posers, a number of inquiries were made in relation to, and the amplitude actually extend beyond the jurisdiction of the courts. So I would also at this stage also be inviting my Lord Honorable Justice Bibi Kanye to also assist in taking on some of the questions I can. We'll be glad to have, again, the very insightful comments, opinions in relation to some of the questions here. Yes, my Lord. The very first question, which I would like to pose, is illegal for my Lord, a colleague has asked, and then he has said that the questions are a very few questions. And like I said, not necessarily to do with the jurisdiction of the court. And the questions are as follows. Can an employer impose a 3-month notice period for resignation on an employee after the employment contract has been signed? Can new company policies have a retroactive effect on employees? Can an employer remove a payment in lieu provision in cases of resignation from his employer? My Lord, I recognize that some of these questions might probably border on life scenarios, very factual dispute that will come before the court. So we'd not like to put my Lord in a difficult situation in preempting the mind of the court on matters before the court. My Lord can talk about, and of course, my Lord had earlier given the caveats that this does not necessarily represent the opinion of the courts. So that said, I don't know if my Lord would want to help us with that question. If I can take them again, can an employer impose a 3-month notice period for resignation on an employee after the employment contract has been signed?
Well, a contract of employment, like every other contract, is a transaction involving the consent of the parties to the relationship.
Yes.
And one fundamental principle of the law of contract is that neither party can unilaterally amend the terms.
The terms, yes.
A contract of employment is consummated upon the issuance of the offer letter and acceptance by the employee.
Yes.
And after resumption, the employer lacks the powers to amend the contract without the consent of the employee. For there is a South African case that even the employer cannot alter the salary of the employee without his consent.
Yes.
So at that point, the employer cannot impose a 3-month notice of resignation after the resumption of the employee. To do so, there has to be a consensus, a discussion with the employee, and the employee must agree to that new term, because that's an amendment of the existing terms of the contract, and the employee must agree to it.
Before you can.
The problem then may be is that if the employee refuses to accept the new terms, he may be asked to leave the company. But beyond that, it can be forced on him.
It can be forced on him, yes, my Lord. And there's also a related one that can new company policy. Okay, I see that Dr. Uche Arthur has raised his hand. I do not know if Doctor wants to offer further comment in relation to the question or has a question. Dr. Arthur, you have the floor. Please go ahead. Unmute yourself and speak.
Okay, thank you very much, Leonard Silk.
Yes, sir.
It's just to widen the response given by Milord, and it's to bring the issue that most contracts of employment, though fundamental to the relationship, will in practice also contain a clause. And the clause will be to the effect that this contract is also subject to policies that will be made by the company from time to time. And therefore, no contract will actually be conclusive in the employment area, since the organization recognizes that there is a lot of dynamism in the system. And therefore, from time to time, policies may change. I would like to get Milord's comment based on that. Hardly will you find any contract of employment without that kind of clause.
What,
Yes,
Doctor?
what happens?
Yes, okay.
What happens in that case is that the employer would need to notify the employee. And upon notification, the employee has a right to accept or reject. So, and like I said earlier, the consequence of rejection that the employee will be forced to leave the employment or be asked to leave the employment. But it is not obligatory that once the policies are reviewed, they become binding. They can't be binding until the employee is notified.
Absolutely.
And accepts the review.
My Lord, if I may
In
just...
one case, hold on.
Yes,
in a case, the judgment was delivered on the 27th of July. A similar situation arose. And the company hired this young man as a youth corper. He grew through the ranks, became a manager. They feared he might move to a competing company and amended the contract of employment and forwarded it to him with a note that it must be accepted within a particular time and he must provide a guarantor. The employee saw the letter and knew that it was going to bind him. He refused to sign, he refused to provide a guarantor. Nevertheless, he was paid salary, ostensibly on the basis of the new contract. Now he resigned and moved to another company. They came to court. At the end of the day, it became a question of interpretation. Was the new clause binding on him? After a review of the circumstances and facts, we came to a conclusion that it was not. Because the two conditions were not fulfilled. One, he did not accept within the time frame, and by the law of contract, the offer lapsed. Two, he did not provide a guarantor, which was a condition precedent. And where there's a condition precedent and it is not fulfilled, the contract is discharged. So going back to what Dr. Arthur said, while some institutions have a clause that the rules could be amended, but such rules will not be binding on the employee until he is notified and consents to it. And remember that acceptance will be by conduct. So where the employee does not challenge it by saying, I do not agree, either by a mail or verbally, and continues to work under those new conditions, it becomes binding.
Excellent, Falabi.
Milord, yes. Sorry, Milord, yes, Milord.
Let me add to Dr. Zuweneka.
Yeah.
There are some basic rules we need to understand. One, in the event of ambiguity, you must interpret ambiguity in favor of the employee. Even the Supreme Court has acknowledged that principle from us. Once again, I must commend Honorable Justice Ogwumiju for that. She cited some of our decisions where we laid down that principle and applied it. In the event of ambiguity, you must have ambiguity in favor of the employee, because as between the two parties, the employee is the weaker party.
Yeah.
That's one. The second point is, in general, please mark my words, in general, an employer can change the conditions of service subject to consultation. Where the change is beneficial to an employee, you don't need the consent of the employee. An employer can increase salaries, for instance. That's a change in the conditions. The employee, of course, if he does not want the benefit, he can turn it down, but you don't need his consent to be able to do that. It is where the change is not beneficial to the employee, then you need consultation, and everything that Justice Weneka has said will then come to play. If the gentleman says, I'm not accepting, and he walks away, you can't bind him. You can't bind him. So yes, an employer can change conditions of service where they are beneficial. You don't need the consent of the employee. Where the mental, then you must consult, and it's up to the employee to accept it or then move on with his life. I just thought I should emphasize this.
Thank you very much, my lord. And I mean, I had actually wanted to add that even in the context of the question asked, whether the employer can impose 3-month notice period for resignation after contract, I would imagine that that's a fundamental term of a contract. I mean, every contract must have terms relating to how the contract can be discharged in the event of either party deciding to walk away from the contract. So, and a fundamental clause as how it can be discharged, I would imagine, cannot be left hanging to be subject to some future contractual document that the employee will be faced with when it comes in. Melo, thank you very much for that. Melo, whilst at this, there is a question.
SN, even on that, even on that.
Yes, Melo.
That question, I want to assume the employee got into the contract maybe on the basis of 1 month's notice. Then it was changed to 3 months notice. That is not a beneficial clause. That is not a beneficial clause, because if you look at the Labor Act, you look at Section 34 of the Constitution, and then ILO Convention on Forced and Compulsory Labor. You can't force an employee beyond a period he wants to stay. And that is why resignation takes effect if it is so desired by the employee. And that is why, for instance, if you remember the Unity Bank clause, where the Unity Bank case, they had a clause in their conditions of service which said that if you are being investigated for a wrongdoing or a misconduct, you cannot resign or you cannot leave. In fact, there's a Court of Appeal decision that has even acknowledged that a suspended staff who is suspended because of wrongdoing cannot leave. My colleague, Justice Obaseki too, also did a similar decision following the Court of Appeal decision. But in both decisions, both that of Justice Obaseki and the Court of Appeal, Section 34 of the Constitution was not considered. I think Section 71 or so of the Labor Act was not considered. Neither were the ILO Conventions on Forced Compulsory Labor considered. So when I had a similar issue before me, I distinguished these cases on this ground and then held that no, there are other Court of Appeal decisions that says the right to leave an establishment is absolute. You can't place terms and conditions that the man does not want. If he wakes up and says, I want to go immediately, subject to paying the notice period, he is free to go. If he does not pay the notice period, then of course the contract of employment usually has provisions as to whether or not to allow him to go or not to go. So on those bases, I held that you can leave, and anything stopping you from leaving is tantamount to false labor. A corollary is Section 6 of the Constitution in relation to constitutional office holder. Take a careful look at that provision. Section 306 of the Constitution is very specific that for all constitutional office holders, once they tender letter of resignation to the person authorized to receive such letter, resignation takes effect immediately. Now, if the Constitution can do that for constitutional office holders, how come we want to give a different interpretation for other workers simply because they are low-level workers? Sorry to use that term. Sometimes we need to borrow principles here and there and see how these things are treated. So, yes, I don't think it is right for an employer to change his conditions of service and impose a higher period of notice different from what was there if it is not accepted by the employee.
Fantastic. My Lord, I thank my Lord very much for the clear analysis given to, in addition to the thoughts already expressed. My Lord, the questions are coming in, and someone has actually asked us, or is trying to, has advised that perhaps we should focus more on questions relating to the subject matter of discourse today. So I would, in that light, ask 3 questions that are related and that a few of our colleagues have asked. And 2, I'll be posing the 2 immediate questions to my Lord Justice Iweneka, and I would also pose 1 to the Honorable Justice Bibi Kanyib. Now, so my Lord Justice Iweneka, the questions are these. Does the NIC also have jurisdiction over fundamental human rights cases in employment, in employee-related matters? From my Lord's analysis, it appears it is the case, but thought to confirm. Now, whilst my Lord is at that, my Lord should also consider this question. Does the NIC have jurisdiction in a case of wrongful dismissal of a military officer? And for my Lord, Honorable Justice Bibi Kanyib, and Mr. Jami Akolade has asked if my Lord does not worry that the Alpha-Sin decision, that the Alpha-Sin decision is the decision my Lord earlier referred to, and recently made, explaining the distinction and narrowing the jurisdiction of the courts when it has to do with contract of labor, contract for labor, contract of service, and contracts of service. So Mr. Akolade's pointed question says that it would appear that this decision will ultimately overwhelm the court's docket with a deluge of commercial dispute. This is in view of the fact that virtually all commercial contracts would definitely involve some form of labor. We would like to hear my Lord's thoughts on that. So, and then we'll come back to another round of questions. Yes.
Are you starting with me or with Justice
Iweneka? My Lord can start. My Lord can start. Yes, my Lord can start. Yes. My Lord Justice can.
Okay. Yes. I don't think the court will be overwhelmed.
Yes.
Yes, the first impression is to think that the decision is far-reaching, very wide, and so on. I like to look at matters more on a case-by-case basis and as they come. Of course, the context within which that decision was made in terms of the jurisdiction of the court had to do with the interpretation of a contract. If you know, those of us who are in Abu, you know Prince and Princess. There was this contract that was given out for certain services, security, management of the estate, and so on. Something similar to the contract for supply of service that we saw in Shino, Securities and Afropac. Even those of us who are in government service, in the National Industrial Court, for instance, as any other government office, security guards are outsourced. That's cleaners are outsourced. That's true. Now, if you look at the context in which those decisions were made, there are contexts in which the question of outsourcing is involved. And ILO says outsourcing is disguised employment relationship. In other words, an employer is trying to hide away, move away from responsibility into something else. He wants to make it look like I am not your employer. But he controls how things are done and matters like that. And then one other point, let me better say it here. I keep hammering about new forms of work, new forms of work, new forms of work. I will urge lawyers to do a more detailed research into these new forms of work. I've done a little bit of study in this area, and it's scary. When I say it is scary, we will wake up one day and discover that the traditional work relationship we understand is no more. And that's the plain truth. Now, how are we going to come to terms with this? In the first instance, there is also that self-in point I must make as head of the NIC. These new forms of work keep coming and changing the dynamics of the workplace. NIC may wake up one day and discover it does not even have jurisdiction any longer. Particularly the point I kept hammering. If we keep insisting that the jurisdiction of NIC must be tied to an employment relationship, as long as there is no employment relationship, then there is no jurisdiction for NIC. So even for that self-serving, sorry to use that word, for that self-serving reason, we're a bit careful at the NIC. We're also watchful, we veil, so that you don't just, how do I put it? You don't just becloud a relationship simply because you don't want to come to NIC. And we have seen instances where even in the coinage of the claims and reliefs, matters that ought to come to NIC are taken to other courts. Within us in the court, when I say us, I mean the judges. I've heard so many of my colleagues complain, this particular instance shouldn't have gone to this high court. It should be to us. And I tell them, look, I'm not the kind of person who goes out looking for work. I'm not the type who will be urging lawyers, look, come and file in NIC and not another court. When you go there and you face the problems and you mess up, you will know the utility of having to have come to NIC in the first place. That's what I keep saying, because whether we like it or not, in NIC, you have a fairly straightforward jurisprudence, a fairly straightforward literature that binds you. Of course, we have a leverage of flexibility and informality, which is also another plus for us, because at the end of the day, we simply look at what mostly should be the justice of the case and go ahead and do it. So yes, to go back to the question, I do not really think that the decision is as advanced, let me put it that way, as carry virtually everything under the earth and bring to NIC. I don't see how the docket will automatically move from the over 6,000 cases we have now nationally to maybe 25,000 that you would see in normal high courts. I don't think that decision will yield to those number of cases coming to NIC.
Thank you, Madam. My Lord Justice Monica.
Yes. The first question is on fundamental rights.
Fundamental rights, yes, Madam.
Like I said during the presentation, the court exercises jurisdiction on the basis of the facts and circumstances of each case. So depending on the form of the fundamental rights claim, the court may, based on the facts, either assume jurisdiction or decline jurisdiction. I'll cite a few examples. If an employee is arrested on his decks for an offense he did not commit, and he's discharged by the authorities that arrested him, and he goes to court, of course, he's still in employment. The question is, did it arise in the course of his employment? It did. So where the subject matter of the claim arose in the course of his employment, the court will most likely exercise jurisdiction. I'm saying that advisedly. But where the employee had left, we have had cases of employees who are arrested post-resignation or post-cessation of a relationship. Of course, the question is, did the arrest or the violation of their fundamental right arise in the course of their employment? That will be subject to the facts presented before the court. Then the other question is on dismissal of the military officer.
Yes, my lord.
I was just looking at section 6, subsection 6, paragraph B. It says, the judicial powers vested in accordance with the foregoing provisions of this section shall extend to all matters between persons or between government and authority and of any persons in Nigeria, and to all actions and proceedings relating thereto for the determination of any question as to the civil rights and obligations of that person. And the National Industrial Court is a court under the Constitution. And a military officer, notwithstanding the fact that a military officer is an employee, if he's wrongfully discharged and he believes he has a claim and comes to the court, we will attend to it. And we have done that in so many other cases. We treated cases of wrongful dismissal of police officers. There have been cases from the National Industrial Court, even dealing with wrongful dismissal of military personnel. So the court will exercise jurisdiction given the facts of the case.
Thank you so much, my lord. While still on jurisdiction, my lord Justice Wineka, there's also a question: does NICN have jurisdiction over removal of non-executive chairman of a limited company, which is regulated by CAMA? Well, essentially, does NICN have jurisdiction over removal of a non-executive chairman of a limited company?
Well, it depends on how this is. The truth is, you cannot determine a case without looking at the facts.
Right.
So what are the facts will determine whether the court will assume jurisdiction or not. The fact that the company is raised under CAMA, our jurisdiction is subject matter, irrespective of the persons or the claims.
Yes, my lord.
So it's not the claim that determines the jurisdiction of National Industrial Court. It's not the persons involved, but the subject matter.
Yes.
So if the reliefs are within our jurisdiction, the court will exercise jurisdiction.
Yes, my lord, I absolutely agree. Thank you so much for that, my lord. My lord, Honorable Justice Bibi Kanye, two sets of questions, my lord, that I will just take together. One relates to trade union, and I saw it's still the jurisdiction of the court. Somebody asked, what is, can I assume jurisdiction? Okay, no. Okay, my lord, I'll just take them in the order in which they occur here. Thanks so much for your lordship, for the insightful presentation. I would, however, need a clarification as to whether the remedy for bringing the action in the wrong court is to strike out or a dismissal. Does the statute of limitation begin to run whilst the action is pending at the NICN? And the other question, in my institution, okay, what is the legality of the NICN adopting international best practices that have not been domesticated by the National Assembly in view of Section 12 that says there should not be no court, no treaty between the Federation and any other country shall have the force of law except domestication, that is the provision relating to domestication of treaties in the Constitution. Well, my Lord, I think my Lord has dealt with that in quite a number of cases. So let me skip that and go to just refer to. If an employee walks away, if he does not accept changes to the contract terms, could that be seen as constructive dismissal? My Lord, I'm not sure. I would let also still skip that. With regards to the changes in terms of contract, general principles noted and agreed, but how would the court regard the situation where an employee expresses reservation in writing, but so works to preserve his economic interest, then challenges after leaving work, for instance? Would the economic duress or the unequal bargaining power come into play for the court to hold differently? Yes, I think that's a...
Basically, section 169 of the Evidence Act will work against him. Because by rejecting the term and continue to work because you need the money, that is conduct, acceptance by conduct. And you're not allowed to reject on one hand and accept on the other hand. When you reject, hold on, when the employee rejects, you have to wait for the response from the employer. And if the employer does not respond, having received your letter or notice of rejection of the term, by the law of contract, silence is deemed acceptance. So the employee will be deemed to have accepted what you have done is making a counteroffer by your rejection.
My Lord, let me add, I was trying to remember a case, and I think it's called CFRN. The principle or the rule that industrial courts adopted in that where the aggrieved employee expresses his reservation on, I think, I'm trying to remember it clearly now, on, I think, the letter
let me help
communicating his entitlement, but subsequently goes ahead to bring an action even after accepting. So he's accepted, but he's expressed his reservation, almost like the rule in Pinel's case, no working to discharge him for him to still be able to make a claim, even though he accepted the money, but he's expressed his reservation. Is it almost not the same?
It's a different situation. It's a different situation. Okay. But the president wants to speak.
Yes, brother.
Let me come in here. It depends on what the employee is rejecting.
Yes,
Justice Weneka is talking about rejecting terms and conditions.
Yes.
The Kurt Severenson case had to do with payment of money.
Yes, yes.
The amount of money said to be the entitlement of the employee was laid down in a document, and the employee was asked to sign as full and final payment of his entitlement.
Yes, yes.
The employee signed, but wrote underneath, this does not represent all my entitlement.
Yes.
The idea was, let me collect a bird in hand first, then chase the one in the bush.
Yes.
So he now came to us, and I remembered I did the case. And the question was, an employee who is bold enough to say, this is not my entitlement, shouldn't he have a right to come to court and say, my entitlement should be X, Y, Z, minus what I had already collected? You know, there's a principle of law set, I think, by the Court of Appeal or Supreme Court that says, if you collect final benefit, if you collect money as terminal benefits, you waive the right to come back tomorrow to say, no, I didn't resign.
Yes.
But here, the employee said, I am accepting this money, but it is not my full entitlement. It's almost like saying what you call signing under protest.
Yes.
And I recognize the fact that in signing under protest, he has a right to come to court and challenge it.
Mm.
So that was the point that was made there. Of course, the scenario will differ where the employee, you give him terms and conditions, change the terms and conditions, and he says, I am not going to agree to these terms. Now, he continued working with you after telling you, I don't agree with these terms. For me, it will still boil down to what a court of law will say at the end of the day. I'm not going to be as direct as Justice Weneka by giving you an answer here, because I would want to know the conditions in which he said, I am not accepting. Are the conditions given to him on a take it or leave it basis? Were the conditions given to him as some kind of intimidation, some kind of duress? Those are the things I would like to know first. So I'm not going to give you the straightforward answer that Justice Weneka has just given you on that issue. I will still want to see the details of those facts, because I want to know the conditions in which he turned down and yet remained in work.
Mm.
Those will determine for me how the justice of the case should go at the end of the day.
Yes. Okay, thank you very much, my lord. So my lord can now answer the question I'd asked. And then a few persons have actually come back to insist that they would like to have the thoughts of the courts. Okay, all right. Let me just read questions again. I'll be 50 minutes. Okay, no, sorry, my lord. There are quite a number of them, so I'm trying to sift through the one related to jurisdiction first. Okay, my lord. The rule, the seeming consistency of the court in relation to termination without notice. Mr. Muchala has said that the court, Justice Kanyip has emphasized the need to apply international best practice, sequel to the enactment of third alteration. The NICN had, in a long line of cases, maintained the position that employers must terminate employment by giving valid reasons, in line with Convention 158 ILO. Although the convention is yet to be ratified in Nigeria, it was usually applied as international practice where same is pleaded and proved in line with Order 14A of the NIC rules. However, in recent times, it would appear that the NICN is reverting to the common law position that employers can hire and fire without giving a reason or valid reason, even in cases where Convention 158 is pleaded. My lord, I relate with these questions. Even one or two that I have read in recent times, not necessarily Convention 158 came into play, but the court was quite emphatic that something leaning towards the common law position that the employer can hire and fire without giving a reason. So this concern has now been raised by someone here that it would appear that the industrial court is back to, or is gradually drifting towards that position. That is one. Two, yes, my lord. Does NICN have jurisdiction over the leadership of trade union in relation to who has a valid registration with the Registrar General?
Of course, the answer is yes.
Yes.
When you said Registrar of Corporate Affairs Commission.
Yes.
So if you are talking in relation to the Registrar of Trade Unions, the answer is yes, we have jurisdiction. You only need to go to section 254C1 and you would see we have jurisdiction over trade unions. We have jurisdiction over interpretation of constitutions of trade unions. You can't determine the leadership of a trade union without reference to its constitution and so on. So we have jurisdiction over that. That's not a problem.
Yes.
Let me go to the issue of Convention 158, best practices and all that stuff.
And
best practice is another name for culture. Best practice is another name for usage, for culture, for convention. What is the rule in the Evidence Act? Custom. If custom is said to be subject to proof, and the proof requires corroboration. Now, if in one case a particular custom is adopted and proved and applied, in the second case, the Evidence Act says you can take judicial notice. So, if in one case NIC applied Convention 158 as best practice, on the assumption, I'm assuming here, that it was pleaded and proved, in a subsequent case, I'm at liberty as a judge to simply say, Convention 158 has been proved as evidence of both best practice. I'm taking judicial notice of it, and consequently, I will apply it.
Yeah.
I will be perfectly within the law to do that. What was this other point you raised?
Domestication of treaties, Section 12, and the position taken by the industrial
So Section
courts.
12, you only need to read the opening words of Section 254C1, notwithstanding anything in this Constitution. Section 12 is anything in this Constitution. And Section 254C had already given NIC power to apply conventions ratified. In fact, for conventions ratified, you don't even need proof. All you need to do is show that they have been ratified. And the easiest way to show ratification is go to ILO website, click Nigeria Ratified Convention. They list out all the conventions that Nigeria had ratified. You would see them listed there. So that is sufficient proof. I understand the Evidence Act has been amended to incorporate some of these things in terms of Section 84 of the Evidence Act, which allows you to incorporate electronic evidence and all that stuff without much problem. And so there was this other issue you raised relating to customs usage.
Yes.
I've forgotten the bit of it.
That's still
It
the
has
one
escaped
related
my
to-
mind.
Okay.
No, there's a final point you raised.
Okay, I think that's still the one relating to. Oh, my lord, back to the growing, what would appear to be a growing culture of reverting back to
Of
the days
NIC
of common
going
law. Back to the days of common law. Yeah.
Yeah, that's the point that skipped my mind. Here, I want everybody to mark my words here. The problem is not NIC. After all the decisions NIC have done, there are recent cases. In fact, there's a Court of Appeal decision where they were very specific about NIC did a case where it held that termination for services no longer required is not good enough. And NIC held it to be wrong. Court of Appeal upturned NIC on that issue. So if you look at majority of what NIC is doing now, they're a product of the reversals of some of the decisions we got at the Court of Appeal. And that's why I have always made the point. Luckily, I have an invitation by the President of the Court of Appeal to talk about recent developments at the Court of Appeal retreat coming up. These are some of the things to draw attention to. Here, I was reading a paper delivered by one of the UK Supreme Court lords, and he was talking about precedent. And he made a point about precedent that I don't think we ever acknowledge in Nigeria. And that is that appellate courts should be wary about tampering with long-standing case law of lower courts, where people have adjusted their affairs based on. Our understanding of precedent is that a lower court is bound by a superior court decision. That's our understanding. But here is the UK Supreme Court law saying the reverse is almost like a precedent. Lower courts are used to a particular, in fact, I used something similar in the ASU case I did, where there was a challenge as to the referral system. I was told that the referral system, where the Minister of Labour apprehends a trade dispute and sends it directly to NIC, bypassing mediation, conciliation, and arbitration, was wrong, null and void. In looking at that preliminary objection, I think I did the judgment, was it on 28th of March or so, the ruling, 28th of March this year or so. I rejected it and I said, no, you have to look at even the long-standing cases on the issue. which attempt was made to distinguish, but for me, in that ruling, I pointed out that they were a poor appreciation of what those cases actually stood for. Because when you talk about referral, I stress the point that there are two forms of referrals. You have referral from the Minister of Labor based on an IAP award where there's an objection, or you have a referral, what we call direct referral, where the Minister of Labor decides to bypass all processes and either sends the matter directly to IAP or directly to NIC. And here, I need to make a point, which I think should interest the lawyers. Sometimes lawyers, because they hardly appreciate what they need to do to us in a wrong manner. The processes of Part 1, the dispute resolution processes of Part 1 of the TDA are still in effect. They are still existing processes. If in any trade dispute, inter and intra-union dispute, luckily, the Court of Appeal decision of 2020 in Makodi Division, Nasu versus Jacob, acknowledged that for inter and inter-union and trade disputes, the processes of Part 1 must be exhausted before you can come to NIC. There's another Court of Appeal decision which also, in fact, it came harshly on a counsel who did not wait for the IAP award to be sent to him, short-circuited the process and came to NIC directly and filed an appeal over an IAP award that was not sent through the Minister of Labor. The Court of Appeal said, to use the language of the Court of Appeal, that counsel could not jump the gun. Now, what point am I trying to make? These processes are still valid. And if these processes are valid, it means that lawyers who, for instance, and I've seen several of them, decide to turn a trade dispute into something to file by way of originating summons, using the argument that because IAP is not a court of law, it cannot grant injunction, it cannot grant declarations. I did a case where I analyzed some of these things. In fact, I went as far back as Western Steel, decided by Justice Karibi White with a concurring judgment by Justice Oputa. It was Justice Oputa then who said, because NIC was not in the Constitution, it was not a court of law, so to speak. It's not a court of law, so to speak. It cannot grant injunctive reliefs or declaratory reliefs. And I asked the question, what is an injunctive relief? It is to restrain you from doing something. What is a declaratory relief? It is to determine the rights, legal rights between parties. Now, even in an arbitration award, most lawyers are now arbitrators. When you act as an arbitrator and you make an award, do you make an award in the absence of determining rights and obligations of parties? The answer is no. So sometimes I keep saying it that we refuse to contextualize certain things. And because we don't do that, we never get to the bottom of it. You can't make a blanket statement that you can't make a declaratory relief, when by definition, declaration is simply a statement of rights, privileges, and duties. There is no way as an arbiter in an ordinary arbitration agreement where there's a dispute and you are asked to arbitrate, that in making that award, you don't determine the rights, obligations, and duties of the parties. It's just not possible. In any event, everybody cites Western Steel, Justice Oputa, forgetting that the lead judgment in that particular judgment by Justice Karibi White acknowledged that what Justice Oputa spoke about were issues that were not on appeal before them. That was the first thing Justice Karibi White said. So when Justice Oputa was talking about you cannot grant declaratory relief, you cannot grant, all those things were obiter, because they were not part of the grounds of appeal, the issues on appeal before in which the lead judgment, I think it was Justice Nick Itobi who said, a concurring judgment that goes outside of the lead judgment is on its own. It's as good as a dissenting opinion. But in life, we have a way of glamorizing some of these things. Of course, Court of Appeal, I think it was Justice Ipombe of blessed memory, who applied Western Steel as if it was the ratio, as if it was the lead judgment, and so on. So you can afford to say, if Western Steel is not binding on you, then these other Court of Appeal decisions that took them are binding on you. In any event, as a court of first instance, you are told that whether the decision is right or wrong, you are bound by it. It is only that court or a superior court that is bound to, that can change it and say, look, what we did is wrong, and can alter it or something. But for us, it still does not stop us pointing out that, look, especially in fora like this, the fact that this was done and it is binding does not mean it is right. We are saying this because some of us who are lawyers today listening, tomorrow will be judges. Next tomorrow will be appellate court judges. The following time, they are going to be Supreme Court judges. The fact that we were wrongly learned does not mean we should not unlearn. That's the point. We sometimes make these statements, yes, we are bound by it, just like the complaint is being made, NIC appears to be going back. We appear to be going back because majority of the Court of Appeal decisions over our decisions have overruled us on some of these points. And there's nothing we can do. In fact, I have read a Court of Appeal decision where Justice Obaseki was overruled. And what was it? She applied a Court of Appeal decision that said that awarded damages in terms of not award damages, deemed determination to be on the day of the judgment. Given the fact that suspension was a long period, nothing was done, this kind of thing you have from employers. They suspend you and keep you in limbo. They don't tell you you've been found guilty, you've not been found guilty. You are not recalled. You are just left hanging. And this thing took for years. The Court of Appeal in that decision said, no, yes, there is an intention to terminate, but we are going to deem that termination as coming into effect on the day of the judgment. Joseph Obaseki did similar thing, but the Court of Appeal in a more recent case, I think it was in 2021 or so, I can't remember. Very specifically, I think it was Calabar Division, Court of Appeal, that said no, that the very fact that there is an intention by the employer to terminate, the termination takes effect from the moment that intention is exhibited. So Joseph Obaseki was wrong to have held the termination to take effect from the date of the judgment. So when you are faced with Court of Appeal decisions such as this, what are you going to do as a court of first instance? These are the problems we are having. So it is not that NIC is going back.
My Lord, it
is common law.
Yes. But I'll just
I started off by saying,
yes. I actually want to
let me just finish. I started off by saying that we cannot assume the third alteration was meant to retain the status quo. That's the point I started with, and I want to end it with it. If we assume that the third alteration did not change anything, then it means we are going to be applying common law principles. If Court of Appeal speaks, there's nothing NIC can do. So we are not going back because we want to. We are going back because Court of Appeal have overruled us. There are some decisions I have made where I specified my hands are tied. This is what we have done, but because of this Court of Appeal decision, this is what I can't do. We are hoping that one day when these things get back to Court of Appeal, they will have an opportunity to have a rethink.
Hello, that is absolutely correct. But in the meantime, and I'll come back to my Lord, and I'll quickly pose these two questions. At least it would appear that in these two areas, we do not have Court of Appeal positions, inconsistent Court of Appeal positions that the industrial courts will struggle with. So this appears to be firmly the territory of the industrial court. I mean, the position or what would appear to now be an inconsistent position from what the questions there have analyzed. Those two related questions. One, NICN is gradually eating into the jurisdiction of the Federal High Court. An example is cases of leadership tussle in a company registered under Part C of Old Kama, Incorporated Trustee, which is not a trade union. What is the take of my lord on it? And still closely related to that, albeit on another breath, is the question on the jurisdiction of the NICN with respect to employment contract that have arbitration clauses. And Ugona specifically said that in Barrister Raymond Maga and High Quality Bakery Limited, the court dismissed an objection and assumed jurisdiction on the premise that the then ACA only applies to commercial dispute, which does not include employment dispute. That decision appeared to find support in the precedent decision in Ravelli and Integrated Services in 2018. However, in October 2022, Justice Esowe in Chukwudi Egbe and CWG granted an application for stay of proceedings pending arbitration. This creates some confusion. That is the position of the NIC. I know Honorable Justice Kanyim does not like the principle of latter decisions overriding previous, but can we rely on the 2022 decision as the prevailing? I would appreciate my Lord Justice Kanyim's thought. But my Lord, apologies. I would ask that my Lord should hold the thoughts now, whilst I quickly take on a specific question that relates to the paper that my Lord Justice Iweneka addressed today. So I would like to hear my Lord's thoughts on this. What happens in a scenario where the employer is a bank and the employee is also a customer of the bank? The employer is a bank, the employee is also a customer of the bank, but the loan is given to the employee by virtue of his being a faithful employee, that's the way it's put, of the bank that is not a customer. Shouldn't the NIC be able to entertain a dispute emanating from such a loan? That's question. I would like my Lord Justice Iweneka to come on it, and also to, in the same breath, take a question that would the industrial court be able to exercise jurisdiction on harassment, assault arising in the course of work?
Well, taking the last one first.
Yes, sir.
Order 14A of the National Industrial Court Civil Procedure Rules has a provision for harassment.
Yes.
So if an action is filed in our court and complies with all the other rules, and the court deems it necessary to assume jurisdiction, the court will. Like we keep saying, everything is based on facts and circumstances. Those are what determine whether a court should assume jurisdiction or not.
Yes.
Then on a faithful employee being a
yes.
customer.
Yes.
The decision of Odibo and Keystone Bank of 9th December 2022, which is a Court of Appeal decision, is very clear on the point.
Yes, sir.
There must be a nexus between the grant of the facility and his being an employee of the institution. The court drew a distinction. If the loan was granted by virtue of him being a customer, the court will not have jurisdiction. But where it is granted as a staff loan, you can appreciate an employee and give me a car loan, give me a housing loan. But it must be granted qua employee, not qua customer. That is the distinguishing feature. And remember that the clause relating to, connected with, incidental to. The question is it related to? Is it connected with the contract of employment? Is it incidental to it? Those are the things that enable the court to decide whether to assume jurisdiction or not.
My Lord, whilst at this, there is a related question. What is the position of the law with regards to employers who give employees cars without any deduction from salary or provision in the contract of employment with regards to the payment for the car? And would they demand that the employees return these cars upon their resignation? Can the employee lay claim to the car, especially if the document were registered in the name of the employee?
That is
The
in case of
the employee wants to treat the car as a resulting trust to it. Can the employee deal with that? That's a quite pointed question. Yes, sir.
Well, it's not for us to determine here.
As it comes, yes. Thank you so much, my lord. My lord, I'll let Justice Kanye take the other two questions, but I'll return to my lord to shed light on the jurisdiction of the NIC in employment agreement as relates to crew of a vessel, which typically include the rights of the aggrieved master and crew to arrest a vessel for wages. So, my lord Justice,
well, before my lord the president takes over, I will not answer the question.
Yes,
because it is sub judice.
Oh,
and doing a case exactly on all fours with that question.
Okay.
So it won't be wise to
my lord,
answer the question when it is ongoing.
I would let it pass. I'll let it pass. Yes. So, my lord Justice Kanye.
Well, let me add to what Justice Weneka said.
Yes, sir.
You said?
No, but my lord, please go on, sir.
You have to go. I wanted to add something to what Justice Weneka said. Then you mentioned arbitration. Maybe you have to ask that one again.
My lord, I'll come back to it, but my lord can please go on with this.
Okay, the point I just wanted to stress, which again I made the point when I started off. Look at the conditions of service. You bought a car and you gave me. The car is in my name. And the conditions of service, did it say I am entitled to the car and it's personal to me and things like that? For me, these are the things I'm going to watch out for, to be able to determine whether to hold or not. I think I remembered I did something similar